Hey there, I'm estate planning attorney Paul Rabelais, and in this video I'm going to address which is better for your future incapacity planning, a power of attorney or a living trust. So when someone thinks about the reasons to create a living trust, it's not common to first think about making it easier for loved ones to transact for you during your lifetime when you become incapacitated. In fact, when most people think about the living trust, they first think avoid probate. And when someone thinks about having another transact for them in the event of incapacity, they think durable power of attorney. So let's start from the beginning and discuss what can and can't happen if at some point during the rest of your lifetime you become incapacitated and a transaction needs to occur on your behalf. I'm going to address three situations: having no legal plan in place, having a power of attorney as your incapacity plan, and how a revocable living trust can play into your incapacity plan. First, if you have no estate legal plan in place and you get to a point in your lifetime where both you can't transact for yourself and your participation is needed for a transaction, let's say the sale of your home or a piece of property that is in your name, the sale of stock or other investments that are in your name, accessing an IRA or other retirement account that is in your name, then a guardianship proceeding will be necessary so that a judge can appoint someone to be your legal guardian to have the authority to transact for you during your incapacity. These guardianship proceedings are difficult, typically with multiple lawyers involved and with all of the costs and delays involved in a court proceeding or lawsuit. The way they typically work is as follows. Someone hires a lawyer who prepares a petition seeking the appointment of a guardian on your behalf. The state where you reside provides due process protections such as the right to receive notice of the petition, be represented by an attorney, have a hearing on the necessity of the guardianship, present evidence and confront witnesses. After a hearing on the guardianship matter, the court may grant the petition, modify it, grant specific powers, and the court may decide who to appoint as your legal guardian. On the other hand, the court may dismiss the petition. Most people, however, as part of the estate planning process, create a power of attorney. One of the purposes of the power of attorney is to eliminate the need for a guardianship proceeding. With your power of attorney, you designate who can transact for you in the future. Your power of attorney will likely be used in the future if during your lifetime you cannot transact for yourself and your participation in a transaction is required. So long as you have someone that you trust to handle your affairs for you when you can't, such as your spouse, one or more adult children, or another trusted friend or relative, it's common sense practice to go ahead and put your power of attorney in place, because we never know when an illness or injury may occur in the future that renders you incapable of acting for yourself. But a power of attorney is not always a perfect solution for your future incapacity planning. For example, let's say you create a power of attorney and name your oldest child as your agent. Your agent may also be referred to as your attorney in fact. Years later, you get sick, stroke, or dementia, for example, and your investment account at a brokerage firm that's titled in your name needs to be accessed, but you're ill in a big way and you don't have the capacity to be able to enter into a transaction. So your agent, again your adult child, presents your power of attorney, also often referred to as durable power of attorney. Your agent presents the power of attorney to ABC brokerage firm, and ABC brokerage firm says, sorry, we aren't going to accept or honor this power of attorney. Reasons a third party like a bank or brokerage firm refuse to honor a power of attorney can include, they say the power of attorney is too old or it's stale. The financial institution fears the liability that could result from relying on an old power of attorney that may have been revoked or updated. Or maybe the financial institution argues that the power of attorney does not have the appropriate language or wording that the financial institution needs to see in the power of attorney document. Or once I was told by an attorney for a large bank that since the parent had appointed two adult children to work together or jointly on the power of attorney, the bank simply refuses to honor a power of attorney when two people are required to work together as co-agents. Or sometimes the financial institution will want their customer to sign the financial institution's own power of attorney form. But if you're incapacitated, you won't be able to sign their power of attorney form. So this could be a big problem. You did everything you thought you were supposed to do, and now third parties are not honoring your well-drafted legal documents. I will say that some states are enacting legislation to eliminate this problem. The state of Florida, for example, has enacted legislation which requires that a third person must accept or reject a power of attorney within a reasonable period of time. They may not require an additional or different form of power of attorney for authority that is granted in the power of attorney presented, and that a third person who rejects a power of attorney must state in writing the reason for the rejection. And if someone violates these Florida laws, they are subject to a court order mandating acceptance of the power of attorney and liability for damages. So while it may be a hassle to go through the court system to require a third party to honor a power of attorney, remedies are available. So now let's discuss how a revocable living trust may play into your future incapacity planning. Let's start by establishing that the primary reason most people set up a revocable living trust is to enable their survivors to avoid the court and attorney-involved probate process when they pass away. Assets titled in the name of your trust avoid all that. You designate a successor trustee of your trust who, immediately after you die, can manage trust assets and distribute them to trust beneficiaries in accordance with the terms of your trust instrument. But another benefit to creating your trust during your lifetime and transferring title of your home, investment accounts, businesses, and other assets to your trust during your lifetime is that a well-drafted trust will also provide that while you are alive but incapable of transacting as the trustee of your trust, your successor trustee can step in and transact for you. For example, let's say you establish your revocable living trust and you name yourself as the initial trustee, and you name your son Felix as the successor trustee. You transfer your home and your brokerage account to your trust because you want Felix to be able to sell your home immediately when you pass away without having to wait months or years for probate, and you want Felix to be able to distribute the house proceeds and the brokerage accounts to your 3 children who are equal beneficiaries of your revocable living trust. But let's say you have a stroke one day, you can no longer live in your house, and your house needs to be sold so that you have plenty of funds available to pay for your care. Since Felix is properly set up as the successor trustee of your revocable living trust, he will be able to sell your home and access your brokerage account to pay for your care expenses. He won't even need to use the power of attorney or deal with those objections that some parties raise when they are presented with a power of attorney. So the solution for many includes creating your living trust, not only for probate avoidance purposes, but to make it easy for your successor trustee to manage your trust assets during your lifetime if you become incapable. Of course, you will also want to have that durable power of attorney in place so that your agent will have the best chance of handling non-trust matters without difficulty. Finally, make sure you like, subscribe, and click the link in the description for a quick and easy jumpstart to the creation of your estate plan where you leave your legacy for those most important to you. Have a great day.